Please send through any questions through the different portals. This is my first time doing this format of being the presenter and doing questions at the same time, so bear with me. But please send through your questions and comments, and I'll try to incorporate them in as we go. Also, please let me know what industries you are all in, and at any time right now, would love to hear from you. Please, I saw some before. We have some from the veterinary industry, and as well as the technology industry, video game industry. And just some background on me. I am a lawyer with Murdoch Chain Legal Practice, and I mostly work with startups and SMEs. And I'm a Australian solicitor and U.S. attorney, president of the North American Australian Lawyers Alliance. And before I moved down to Australia, I had co-founded and was COO and general counsel of a online market research, open source intelligent data mining business back in the U.S. called Morning Consult. So let us jump in. Payments industry, awesome. Before we start, I think I covered all that. Yes, this is just general information today and no substitute for legal advice. So an overview, as most of you have probably heard, cybersecurity has been in the news quite a bit lately. There has been a massive increase in different type of cyber crimes occurring and cyber incidents occurring in Australia and globally. That's everything from phishing to ransomware to brute force attacks by state actors and cyber criminals. And here is some data to throw at you. Australia is the 6th highest targeted country in the world for cybercrime. And these other two statistics I saw floating around the internet. I don't know how accurate they are. Didn't spend the time finding these citations just because there's so many different stats out there. But nearly 50% of all recorded cyber attacks are targeted against SMEs, and this is the worrying one. 60% of all small businesses who experience a breach go out of business within this first 6 months, or within 6 months of the actual breach. So I want to start by going into the Privacy Act, and this is probably the one that everybody knows the best, or hears about. And the Privacy Act and your obligations under it is regulated by the Office of the Australian Information Commissioner. Probably heard of the OAIC before. But what a lot of people don't realize is how do you find out when it applies to you? And as a business, you fall into its regulatory grasps if you're an APP entity, and the benchmark for that is if you have over $3 million in annual turnover. But then, as always, there's lots of exceptions to the rule of other entities, even if you're less than $3 million in annual turnover. And that's if your business buys and sells personal information, you're a credit reporting body, you've entered into an agreement with the Australian government. But what really gathers into a lot of clients that I've been seeing recently that are growing, especially with the NDIS, is anybody who's in the health services. And the health services category is actually much broader than people realize. It's your traditional health services, hospitals, clinics, practitioners, but also gyms, potentially childcare centers and private schools. So that category actually captures a lot of other businesses that would not usually be captured under the $3 million threshold. And there's 13 privacy principles that you need to consider, but we'll only focus on privacy principle 11 today. And that's that APP entities must take reasonable steps to protect personal information it holds from misuse, interference, and loss from unauthorized access, modification, or disclosure. And the question really is, what is this reasonable steps? And reasonable steps, and we'll talk about what is reasonable a few times throughout this webinar, but Reasonable is a changing scale, and that reasonable can change from time to time. And right now, with the implementation of new technologies as it becomes an industry standard to take steps to have hardware that protects for the purpose of cybersecurity, to have different SaaS platforms that allow for monitoring and protection and education. What is actually reasonable changes over time and changes depending on what the reasonable person would be doing. So as time passes and as these methods of protection become more widely available, there's going to be more responsibility placed on every APP entity to increase the steps that it's taking. Now, for entities that do not fall under that $3 million threshold or not APP entities, just something to note is that if you choose to put up a privacy policy, you still need to follow it. And a good case that's ongoing right now is between the ACCC and Google. And ACCC is going after Google for misleading and deceptive conduct regarding steps of they did not take the steps that they promised in their privacy policy to obtain consent before they changed their privacy policy. So we'll see how that turns out. But something that we should discuss as well is what is personal information. And personal information is a very broad term. It's information or an opinion about an identified individual or an individual who is reasonably identifiable, and whether that information or opinion is true or not, and whether the information or opinion is recorded in any material form or not. And then what is reasonably identifiable? Again, bring up reasonable. And reasonably identifiable depends on the amount and nature of the information that's being collected, the circumstances of its collection, and who has access to it. So it's a very broad category, and really, if it's unclear whether it's reasonably identifiable, you should really err on the side of caution and treat that information as personal information. The last thing I want to put down here is that while the Privacy Act, the Federal Privacy Act, the Commonwealth Privacy Act governs all of these different aspects, Victoria, New South Wales, and the ACT also have their own state laws regarding health records. So if you're in the health space, something for you to consider. Now, stepping away from the Privacy Act that you're likely aware of, just to put a little bit more fear into you, is to think about all the other actions that could be taken against you if there is a breach. And there's a few options under torts. Negligence is that general, you have a duty of care, you've breached to act reasonable, and again, back to reasonable, and the breach of that duty of care has resulted in some type of damage. And the same for breach of confidence. Doesn't need to be in a contract. The confidential information just needs to be passed over to a person. They've agreed to keep it in confidence, and you're open to a tort. Now, breach of contract is another option that people may be able to pursue against you if you've put in contractual clauses into an agreement, such as confidentiality, and you breach that confidence, or you've agreed to indemnify another party for any damage to them, to their reputation, for any act or omission. If you've had any a warranty for your goods or services that may fit into this category of keeping things in confidence, if you're in the technology industry, or if you're an accountant, or so on and so forth, it may breach that warranty. And also, if you're holding intellectual property for a party and it gets released, you very well may be in breach of that contract as well. For directors, you have a duty to act with reasonable care and diligence. So if you're not acting with reasonable care and diligence, back to reasonable again. So much of this is reasonable, and all it takes is for one judge to determine that what is reasonable is that you should have been considering cybersecurity, you should have had that SaaS monitoring platform, and you can be personally liable. And additionally, if there is a breach, your shareholders can come and also pursue the company for negligence, for tort, and we see this a lot coming out of other jurisdictions, the US, Canada, the UK, and so it'll eventually come down here too. The precedence is there, and Australian courts love to rely on other jurisdictions as well. So there's a post-breach. Let's say the breach has happened. What steps should you take? If you have insurance, I'd recommend everybody having insurance. If you have insurance, you want to contact that insurance company and check what is required under your policy. Because if you don't take the steps that are required under your policy, they can reject paying or covering you under that insurance. And again, insurance companies, they're actually in the business of not paying. So if they can find a way out, they'll try. We also recommend contacting a lawyer. And if you contact a lawyer and have the lawyer reach out to IT or cybersecurity company to make an assessment, you can capture that assessment under legal privilege. And once you have that assessment done from your cybersecurity company or IT company, you need to stop the breach, but then determine whether or not it's a notifiable data breach under the Privacy Act. And the question is, what constitutes a notifiable data breach? And please, I haven't seen any questions coming in. Please, at any time, send in some questions and tell me what your thoughts are. Don't want to make this just speaking at you the entire time. But what is a notifiable data breach? You need to determine first, was there unauthorized access to personal information, or an unauthorized disclosure of personal information, or loss of personal information? Now, you can think of people coming through and finding a way in through your security, through a phishing attack. But it's not just that. That's unauthorized access. If you send an email and you reply all, that potentially is an unauthorized disclosure if there's personal information that goes to the wrong people. Or if a computer is lost and it doesn't have the encryption, or it could, or even if you leave a briefcase that has personal information on a train and it has personal information in there, those are all data breaches. So the next step is to consider if the data breach is likely to result in serious harm to one or more individuals. You have to actually take into consideration what that information is. So just because there's personal information that's been released, is it likely to result in serious harm? And that can be, you have to take into context the emotional, financial, the reputational harm, physical, if there's any information that might result in people being physically harmed. So the question is there going to be, and this is a decision that you have to make, is there likely to result in serious harm to one or more individuals? And then you have to look at whether or not you can take remedial action. So let's say that you send those emails to the wrong people. Can you ensure that they're going to delete them? Do you already have a confidentiality agreement with them? If you cannot take any remedial action, then you have a duty to notify within 30 days the OAIC, as well as any parties that are affected. And under the steps that you need to take to actually, when you notify, there's guidance put out by the privacy office, but you need to tell them what steps that they should be take to reduce their risks. So if there's bank account information, so you need to change passwords on their login, or do they need to cut up their credit cards? Do they need to monitor their credit? But there's what we recommend is really thinking about getting those comps right. We've seen good instances and bad instances of some companies trying to hide in the bottom, Friday night release, hide in the bottom of their disclosure, talking about how good the company is, that, oh, there's a breach. Probably not the best way, because you have to think about your reputation as well. Do you want this to reflect well with your customers, that you're taking all the right actions and you're being open and honest, you're working with the regulators, you're helping them out to mitigate any risks to them? Or are you trying to just sweep it under the rug? Now, ransomware payments, the don't do it. Ransomware payments. There's a lot of discussion regarding ransomware payments and whether or not those ransomware payments should be made. I can't tell you whether or not you should be making them. It's a business decision for you, but I lean against it because, one, you're proliferating the legal action, you're funding the bad actors. Two, if you look at the statistics, they're not very good around getting your data back. You can find these different tools as software for ransomwares on the dark web and buy them pretty cheaply. And the people who are doing it don't necessarily have the capabilities to even unencrypt your data. Now, hackbacks, everybody wants to take action against the bad actors, but it's arguably illegal under Australian law and international law that Australia has entered into. Think of it as, what happens if you were punched by somebody on the street and you didn't even know who it was, and then you went around trying to punch everybody nearby? The use of a defense argument doesn't help you too much. So we recommend don't do it. Don't hack back. If a data breach occurs, how is it policed if not reported? If it's not reported, or sorry, if you're not required to report it, it's not necessarily breached. You have the option of contacting your local law enforcement. The different law enforcement agencies have different mechanisms or different arms that deal with these types of cybersecurity breaches. So be proactive. Think about what makes you a target. Are you a target because you have lax security measures? Are you a target because you have a contract with the government and are creating designs for submarines for the defense force? Or are you in the business of creating patents and designs that are novel, inventive, and very valuable that foreign states or companies would be interested in seizing or obtaining? So think about what makes you a target. If you're going to, and then think about steps to protect that data. I'd recommend, once you start thinking about where your weaknesses are, getting a cybersecurity plan. Everybody should have a cybersecurity plan about educating, about implementation of the actual processes that you have. If you have these processes and you aren't using them, then what's the point of having them? It should be from the board all the way down to the bottom, getting everybody involved. You should also consider having your data breach response plan. And this one sounds less important, but it is very important to have it so you can dust it off the shelf and you're not running around worried if and when an incident actually occurs. Get cyber insurance. If you already have cyber insurance, see what it includes, but also definitely look at what are the exclusions. Make sure that if a phishing attack occurs and the responsibilities on your staff, that's still covered. If you end up making a payment to the wrong party because you've had an intrusion that is telling you to send money to a new bank account overseas, make sure that that's covered. But also make sure that you have steps in place that if you are going to change the regular banking process of your company, that there is some type of secondary tier for two-factor authentication for that purpose as well. That is a very common exploit where people will get into your systems, get into your emails, see how money's transferred throughout the company, and just sit there and wait and realize where the weaknesses are and send an email saying, no, this month send that payroll to this bank account, or send that payment that we send to this usual vendor to another bank account, and then the money is offshore and gone before you realize it. And get technical advice. We're talking about what's reasonable, what a reasonable person would do, and getting that technical advice is very important. And it's no longer that everything is cost prohibitive. We have my clients, we have several in every state, cybersecurity companies of people that have extensive background with the military, with in the IT industry, and they work with companies of all sizes. Vendor maintenance and consolidation. I put this in because there's a few factors here. It's your vendors. A lot of these big hacks, like the Target hack in the US, that one came through an HVAC vendor. They had a system that tapped into Target's system that was running the refrigeration units, and they were able to gather credit card data because that was the weakest point. So maintaining your vendors and also your vendors of cybersecurity and IT. Think about maintaining, see what they're doing, make sure that they have the capabilities that you need, consolidate them if possible, so you know who you need to contact if an incident occurs. Training and education, you just need to constantly be vigilant. You can do what you can with two-factor authentication, which is important. Don't reuse your passwords. Use a password consolidation platform. I've heard a lot of technical specialists in the cybersecurity field, and I was surprised that they actually say that LastPass is great. Dorothy just said use LastPass. I agree. That is something that has been recommended across the industry. But being vigilant, you're going to need to continue to do that education. It's not just a one-time, one-off. The studies have shown where they run the phishing scams by the IT experts that after just several months, people become more lax on it. So that training needs to continue to occur. And remember that just by having a virus scan, it's a useful tool, but it's not enough. Thank you, Alana. And yes, again, LastPass I've heard is a very good product, but I can't tell you based off of my experience, or based off of my knowledge of not being a technical expert. Now let's talk about some cautionary tales. Uber, these are ones that are out of the headlines from just the past few weeks. Uber had a chief security officer who, this came about 2016, and that chief security officer tried to say that a hack was part of a bounty program. And now that chief security officer, and this is back in the US, this chief security officer has been indicted for multiple charges, and we'll see where that one goes. But that is they're going after him is for trying to hide a breach. And then the next one is the Tesla case, where the FBI arrested some foreign actors who were trying to pay $1 million to a Tesla employee to install some ransomware. So the value, Tesla is a massive company, but people are willing to pay a lot of money to implement these different ransomwares and different softwares. Another one is China. Out of China, this is all over the news a couple days ago about the Australian citizens and residents that had different profiles with this the Chinese connected entity. So we know that Australians are being tracked as well. So other laws to consider that we haven't gone over today is state surveillance laws. Each state has their own surveillance laws, and you need to look into those. The Privacy Act, there's been a lot of discussion regarding the Privacy Act and having updates. It most likely won't be identical to GDPR, but it'll likely be head in that direction. ASX rules, and so the ASX has its own rules that need to be followed for directors. If you're an APRA regulated entity, you need to follow prudential standards. Telecommunication Act has other standards in there for telecommunication companies. And also our friend to the west, New Zealand, just passed about 2 months ago a new act, the Privacy Act, that has it creates a much stronger regime over New Zealand. I put in some resources down at the bottom for you that to check out if your email's been hacked or have been any data on it's been released online. And then cyber.gov.au has a lot of great resources. Tom, I think you were going to jump back in here and have some talk about the special offer.
Thanks, Paul. Before we get into that, we might want to just check first and get to all of the questions.
Oh, sure. Let's see what questions we have. Hi, Paul. I'm interested about insurance companies being in the business not paying out on claims. Yes. Regarding insurance, I always recommend reading through the policies, and the exclusions are a good place to start, but just make sure that what your business is offering in particular is covered.
So Paul, there's a question here from David Fisher. As a website builder and course creating platform, what are the best ways to protect our business?
Well, like we were discussing above, what actions you can take. There's technical aspects, there's the training aspects, and there's putting together plans for when the eventual does occur. And you can be as proactive as you can, but at the end of the day, a lot of these systems will have gaps that you'll have to deal with if they arrive.
Okay, great. And there's a question that's just come in from Alana, and I don't know if you specifically know the answer to this one, Paul. On behalf of a charity in the health domain, do you have any recommendations on the regulatory requirements?
It depends on if you have health data. Like I said, the Privacy Act applies to the local, depending on which state you're in. You also may have the local ones, but you also have charities still fall under the Privacy Act as well. Not sure what additional details we can chat offline if you have any specific questions. Oh man, there were a lot of questions. Sorry, did I miss all those? Yeah, we will be sharing these slides. So Tom, why don't you jump in and talk about the offer? I think we're getting pretty far along in the after the 30 minutes, and I'll start looking through these questions and answer some of them afterwards.
Yeah, absolutely. So thank you everyone for attending this afternoon's webinar. We've got a super special offer for all of those who have tuned in, where we're giving you access to any one of our annual legal plans. And if you take up one of the legal plans for the 30th of September by the end of the month, you'll get an additional 3 months added to your plan at no extra cost. And so we've got two main legal plans for those of us who are familiar and already users of LawPath. There's our Essentials plan, which is going to cover all of the legal documentation that you're going to need, creating contracts, then being able to share them, send them, sign them, and manage all of your contracts in one easy to access place. In there, we've got over 300 documents available for your business. And this is covering a lot of what Paul has discussed today as well, the likes of privacy policies, data retention policies, data breach policies, data sharing policies, cookie policies, cybersecurity policies. We're really covering all of the different areas that you're going to need to be able to put in that infrastructure to be able to protect your business. You'll be able to customize those specifically to the needs of your business, and then be able to deal with needing to publish those ones. If they need to be signed, we've got an end-to-end online signature platform that you can use across any device. And our other offer available around our annual plans is with our legal advice plan. And our legal advice plan is fastly becoming our most popular plan, which gives you on-demand access to lawyers that you can have 30-minute consultations for on new legal matters. And so Paul is one of the members of the network of lawyers that we work with across the legal advice plan. So if you have any specific questions or need a consultation relating to anything that we've discussed, anything around cybersecurity or any of the other areas in which Paul specializes in, we're able to connect you up. You put in your consultation, you'll have access to that. And so you'll be able to access that all year round. And as part of this plan, you'll also get those additional 3 months at no extra cost. And so this is an offer that's available only to new customers. So if you're already a member, this won't apply for you. However, you might have seen if you're already a paying member that we now have a refer a friend program. So if you were to refer a client onto us who then takes up a legal plan, you'll additionally get access to 3 months for every new referral that you make. So there's some great offers for you to check out. If you want more information and if you want to claim these offer, if you head over to lawpath.com.au/webinar, that will take you directly into the offer page where you'll be able to take that up. That's all from me. I'll pass back over to Paul, who will jump into a few of these questions.
Thank you, Tom. 3 questions that came through just a little bit ago, and I think that they'll probably be a good way to end this, and that's regarding third-party providers and breaches by third-party providers. Now, if you have a third-party provider and they're providing a service to you, and let's say you have a client that and those services are being provided by the third party, or they're handling the personal information, or they're handling any of your information, you are responsible for the actions taken by that vendor that may impact your client. If you have a contract that says that they'll indemnify you for any act or omission that may occur, you can hold them liable, but you're still responsible as well to your clients. In regards to, I wanted to just mention briefly that employment data that you hold for your employees is not covered by the Privacy Act, but that is not a great exception to rely on. There's been a lot of discussions of removing that in the future for any update to the Privacy Act. Additionally, that exception over time has been whittled down by the courts, so it's not as robust and broad as just having employees data. People who applied for jobs, previous employees don't fall under that. And then business owners who have websites. There's other services out there, quality assurance services that can check other parties or other developers' work. So I think that I will end it there and let everybody ruminate on everything that we've discussed today. I just really wanted to thank you for tuning in. And there was a lot of information that we covered today. And in the future, this is our first of a series of cybersecurity and privacy topics. A lot of these could have just been handled in a single presentation or deserve a single presentation themselves. And we'll have those coming in the near future. So thank you very much. And I look forward to talking with you again soon.